Hi, everyone. I will give it another minute or two, but if in the meantime you might want to share in the chat where you're joining us from, that would be really interesting for us to know. And then we will start with the event shortly. Hi and welcome, and thank you so much for joining today in this final webinar of this year's online series that ClientEarth is jointly organizing with the Heinrich-Böll Foundation, Green Legal Impact, German Watch, and Arbeitskreis kritischer JuristInnen. My name is Leiden Klingst. I'm a lawyer for public international law with ClientEarth based in our Berlin office. And before we begin, I just want to address a couple of points. I have asked each of the speakers to give a brief input, and then afterwards we will have a discussion together, and we will also open the floor to Q&A. For your questions, please use the designated Q&A box, not the chat. This session will also be recorded and made available afterwards, and you will be provided with a link in your email. We will share a question on your screen now because we're interested to know what your background is, if you've joined any of our events before, and if you could fill that in, that's really helpful for us and interesting for us to know as well. As you all know, today's topic is global calls for climate justice before international courts and tribunals. We had a similar discussion in our webinar last year, and that's why personally I'm really excited to be hosting today's event and hear about some of the developments that have happened since our discussion last year. Oh, sorry, you're seeing the questionnaire on your screen now. For today's discussion, I'm joined by three great speakers who I would now like to invite to join me very briefly. There's Sophie Marjanac, my colleague. She's a senior lawyer and climate accountability lead with ClientEarth. She's also the lawyer supporting the Torres Strait Islanders case, which concluded in a groundbreaking decision by the Human Rights Committee just a few weeks ago. And I'm really excited to have her, and she'll be talking to us about that case today. We're also joined by Margaretha Wewerinke-Singh. She's an assistant professor of public international law at Leiden University, a senior lecturer in environmental law at the University of the South Pacific in Fiji, and an attorney with Blue Ocean Law and lead counsel for Vanuatu in its advisory opinion efforts. And I'm also extremely glad that we are joined by Solomon Yeo. He is one of the 27 law students who formed the Pacific Islands Students Fighting Climate Change at the University of the South Pacific in Vanuatu in 2019. He is now working as the campaign director of the organization and is supporting the leadership of the student body in their collective efforts to take the world's biggest problem to the world's highest court. Thank you all so much for joining me today. I will now give the floor to Sophie Marjanac, who will start us off with a brief overview of the Torres Strait Islanders case, the recent decision by the Human Rights Committee, which found that Australia's inaction political rights. Thank you so much, Sophie. The floor is yours.
Okay, sorry about that. Thank you very much, Leah. It's really lovely to be with you all today and great to see such a strong turnout for this really, I hope, what will be an interesting time together. I am very pleased to be speaking to you today about the result in a case that we assisted a group of Torres Strait Islanders to bring to the Human Rights Committee of the UN. The Human Rights Committee is the treaty body of the International Covenant on Civil and Political Rights. To sum the result up, we were successful and got the decision about 2 weeks ago. So this is one of the first webinars that I have done, actually summarizing and discussing the results of that groundbreaking decision. So I'm really happy to see a great turnout for that today. Before I begin, I would like to pay my respects to the Indigenous elders of the Torres Strait and the traditional owners of the Torres Strait. I'm not speaking on their behalf today, but I will be talking about their land. So it's appropriate for me to recognise their continuing connection to their land and sea country and to pay respects to elders past, present and emerging. I will now begin by giving you a little bit of background for those that might be new to this case on what the facts are and continue to be, and the situation and circumstances of our clients who live in this very remote part of the world between the tip of Cape York and Papua New Guinea. So the Torres Strait is a very small region, only a small chain of islands. You can see not so far from the Solomon Islands. Torres Strait Islanders are a unique cultural group with more of a Melanesian tradition and culture than mainland Australian Aboriginals. Here are the claimants. They are Yesay Mosby, Nazareth Vayu, Danny Billy, Keith Pabai, Nazareth Warrior, Ted Billy, Stanley Marama, and Kebe Tamu. And each of them come from 4 separate low-lying islands. And they were elected or put forward to represent their island communities as part of this case. Under the International Covenant on Civil and Political Rights, minority cultural rights are not, or rather, there are no collective rights. And the case law of the Human Rights Committee prohibits group claims and claims on behalf of peoples. So therefore, the claim needed to be brought by these individuals. However, they were informally acting on behalf of their whole islands with the support of their islands. So what do their island homes look like? This on the left here, you can see the beautiful island of Warrabea. Kebe, Ted and Danny live there. There's about 300 or so people that live there. The population probably swings between 200 and 300 because people do go down to the mainland for various things. The children tend to go to high school on the mainland, or some do, or on other islands. There's no high school on the island. And as you can see, that's the sort of, I don't know, mid to high tide, but the tide is relatively high there. So you can see how low-lying Warrabea is. It's probably between 1 and 4 meters maximum above sea level. And you can see it's also very, very small. The runway, that strip of green is the runway takes up the entire width of the island. So this is clearly a very vulnerable environment to the impacts of climate change, including sea level rise. On the right, the picture that you can see there is an image that shows flooding. So this is Boigu, which is further north from Warrabear. But annually, there is on the king tides, which is the highest tide of the year, there is significant and widespread flooding of the island. Many of the homes are already raised, but we've already seen water damage going into homes, going into gardens, and also into cultural sites like the cemetery. So as part of the case, we gathered significant evidence of the impacts of climate change on life in the Torres Strait, and we put all of that before the committee, including this quote from our client Kebe Tamu, who says, "We have a right to practice our culture and to practice it here in our traditional homeland where we belong. Our culture has a value to us that no money could ever compensate for. Culture starts here on the land. It is how we are connected with the land and the sea. You wash away the land and it is like a piece of us you are taking away from us. The impact of climate change on our culture, sea level rising, coastal erosion, the effect of climate change and coral bleaching on our practices connected with the sea is beyond one's understanding." So I think this quote sums up really the essence of the evidence that we put before the committee. We talked about how erosion and environmental degradation of natural resources on the sea, country, around the islands, and also on the islands was fundamentally impacting the culture of the Torres Strait Islanders. And that is because they are connected to the land and the sea around them. They subsist from the land and the sea around them. They depend on it for their livelihoods and for their cultural survival. And so all of the evidence that was before the committee was really, I think, drawn back to that deep connection that the claimants had to the land. Happily, we were successful before the committee on admissibility. The committee found the complaint admissible, recalled that under Article 5 of the optional protocol, claimants need only exhaust domestic remedies that have a reasonable prospect of success. And it noted that the Australian government, who was the defendant in this claim, had not contested the prospect of domestic remedies existing, and noted a decision of Australia's High Court ruling that state organs do not owe a duty of care for failing to regulate environmental harm. The committee then found that the claim under Article 2, which is was indistinguishable from the merits of the claim under the other articles brought, and found that this part of the claim was not admissible. However, more significantly, the committee found that it was able to take other international treaties and agreements into account when interpreting states' duties under the ICCPR. And this was consistent with general comment number 6. This was a clear area of contestation between the parties. Australia submitted that it was improper for the committee to take the Paris Agreement or the United Nations Framework Convention on Climate Change and essentially international climate change law into account at all when interpreting this international human rights instrument. This argument was really just dealt with very quickly by the committee and consistently with their general comment, and they found that international climate change law and the Paris Agreement was relevant and could inform human rights obligations in international law. So really, they adopted a more harmonized view of international law rather than the fragmented vision that Australia had put forward, which we were pleased about. The committee also importantly rejected Australia's argument on admissibility that the complaint was inadmissible because no one country can ever be held responsible for climate impacts as a legal or practical matter. And the committee found that both adaptation and mitigation claims were admissible, and finding that the treaty imposes positive obligations on states to ensure the protection of individuals in their jurisdiction, regardless of the origin of the threat. Excuse me. This is an absolutely significant and groundbreaking finding. This is the first time that an international organ has found that despite the cumulative and global nature of climate change as a problem, that the law of state responsibility applies, and that individual states are responsible for adaptation within their territory and also for the emission of greenhouse gases from within their territory. So that's one of the most significant findings. Overall, on admissibility, this quote really sums up the committee's findings, and you can see that the particular circumstance of the authors or the victims as peoples who are highly exposed to adverse climate change impacts was relevant to the committee's decision on victim status. And essentially they found that the threat was real, that it was imminent and more than a theoretical possibility. The state had also disputed this in their submissions. So we were very pleased to succeed essentially on most of the arguments that we put forward on admissibility. So now turning to the merits. The majority, so 11 members, found that there was a violation of Article 17, which is the right to family and home, and Article 27, a violation of the right to culture. And they concluded that Australia has a duty to help Torres Strait Islander peoples adapt to climate impacts. The minority also found, so 5 members in 3 separate dissenting decisions, also would have found a violation of Article 6, which was the violation of the right to life with dignity. We had argued for an expanded view of the right to life, essentially arguing or following jurisprudence from Latin America, which in several cases and several decisions of the Inter-American Court had found that for Indigenous peoples, their ability to practice, to remain close to their land, to remain subsistent on their land and practicing their traditional culture on that land, including the burial of their ancestors, and the prevention of that by the state was a violation of the right to life with dignity. So we picked up on that line of case law from the Inter-American system. But the majority did not concur with us on that point. The majority found on Article 6 that within the next 10 to 15 years that there was the possibility for relocation of the islanders, and that accordingly, and that there was insufficient evidence of a threat to the health of the islanders. I think that this is a missed opportunity. All of the evidence that was provided was very clear, and from our clients really showed that for them to be dispossessed of their islands, that would fundamentally affect their experience of life as Indigenous peoples. So I think that there was a missed opportunity there. The minority agreed with us and said that there was enough evidence, particularly around the impact of climate change on subsistence on the island, so on the natural food sources, such as the marine species, as well as the coconut trees, which are a crucial part of survival on the islands, that were also being affected by the erosion and other climate impacts. But we did have a really strong decision on Article 17 and 27, so that was very pleasing. The minority, only 2 members, found that the state also has a duty to mitigate, that is, to reduce greenhouse gas emissions. This slide briefly sets out the main finding on Article 17, which is the right to family and home. And This, I think, really pleasingly picks up on General Comment 6 that the committee made, and committee recalled that state parties must present foreseeable and serious interference with a person's privacy, family, or home, including where that interference results from environmental damage and it arises from conduct not attributable to the state. So that means that the emissions from the effects of climate change, because they are foreseeable, they fall within the state's human rights obligations. And the states must adopt positive measures as necessary to ensure the effective exercise of Article 17 rights. And I'll come to this later, but it's very easy, I think, to see how this finding has quite significant repercussions globally, not just for Australia, but for other states who owe duties to vulnerable individuals, and perhaps individuals who may not appear vulnerable at present, but who, for example, may live on floodplains in Europe and have a serious risk of their homes, their home life being affected by extreme weather events in Europe over the coming decades. I think that this finding on Article 17 is relevant in the European context and can obviously, there are a number of cases before the European Court on Article 8, and I think that these findings will be very influential in those decisions. If we think about the circumstances of the Portuguese children, they are not dissimilar. They are vulnerable individuals facing a foreseeable threat to their family and home life from increased extreme weather in Portugal and in their region. So this finding, I think, has potentially global significance. So the remedy, what must Australia do now? What was the remedy? And what did the committee say on the remedy? Essentially, steps taken by the TSRA is an acronym for the Torres Strait Regional Authority, which is the Australian government organ in the region. The committee found that what had been done by the Australian government to date was just simply insufficient. Seawall funding was delayed, and most actions in the Torres Strait Regional Adaptation and Resilience Plan were incomplete or unfunded. And one of the most significant aspects of the decision is the finding that Australia must implement measures necessary to secure the community's continued safe existence on their respective islands, and to do so on the basis of meaningful consultation with the communities and after a full and comprehensive needs assessment. And this is really what we had asked for, and we were also very pleased to see that there's a compensation obligation also included in the remedy. This is groundbreaking. I've not seen, and other panelists, please correct me, but I have not seen compensation ordered in any climate change case to date. The compensation obligation is without limitation. That is, there's no margin of appreciation provided to Australia to implement these measures subject to other financial constraints or considerations. And this is really a crucial outcome for the islanders, who are concerned to ensure that they have the necessary resources to protect their way of life and their communities. This, I think, is also really important for the upcoming negotiations at the COP and the focus on loss and damage. Finally, a final limb of the remedy that's interesting is that the committee concluded that Australia is also under an obligation to take steps to prevent similar violations in the future. Again, this is potentially a very wide and unlimited finding that has implications that go beyond adaptation assistance to the communities. And our barrister, Monica, has noted that given the acknowledged causes of the violations, which are greenhouse gas emissions, and the environmental degradation resulting from climate change, this must imply that Australia must also take steps to address the root cause of the problem, and that is mitigation by reducing emissions. So that's something that our legal team will consider further over the coming months. And then finally, there is a follow-up obligation that Australia must report to the UN within 6 months. What about greenhouse gas emissions? There was no direct finding on Australia's national greenhouse gas reduction target, unfortunately, from any member. Only 2 members discussed mitigation. Zyberi found that Australia must comply with the Paris Agreement and set a target that is highest possible ambition and have policies to meet that target. Zyberi noted, of course, that if no effective mitigation actions are undertaken, adaptation will eventually become impossible. Land and sea resources will not be available for Indigenous peoples or even humanity more generally without diligent national efforts, as well as joint and concerted mitigation actions of the organised international community. So, as I've just said there, a question that our legal team is considering is, what does this guarantee of non-repetition mean? And does this finding actually imply a mitigation obligation on the state? I think that's quite interesting. I'll just try and whiz through this is my final slide. So hopefully I haven't taken too much time. Implications. The implications are, I think, significant and wide-ranging. Climate vulnerable peoples are owed duties by their states to prevent foreseeable climate-related harms, including damage to homes, family, private life, and the right to culture of minorities. Compensation may be payable by high-emitting states under human rights law. States must urgently review adaptation policies to assess impacts on vulnerable groups. And climate litigators should consider the impact of these findings and how this could be used in national and international litigation. And I'm sure that in our discussion, we might talk about how this could potentially affect the effort of the Pacific Island students to request an advisory opinion from the International Court of Justice. So I am slightly concerned I have gone over time, so I will stop there and leave questions for our panel.
Thank you so much, Sophie. And first of all, congratulations on this great outcome. Yes, we'll collect questions and address them a little bit later on, but you just spoke to us about compensation, continued existence of communities, and also the relevance of international environmental law instruments when interpreting human rights obligations. And some of these themes have also emerged around Vanuatu's efforts for an advisory opinion from the International Court of Justice on human rights and climate change. And so I'm really happy that we have Margaretha with us here today to tell us a little bit more about her work on this important issue.
Thank you very much, Leah. It's wonderful to be here today with all of you. It's a pity that I can't see all of the participants online, but I hope that perhaps during the interactive discussion, I'll have a chance to interact with you, see who you are, and hear your questions and views on climate change, climate justice, and international law generally, and specifically also about Vanuatu's initiative to seek an advisory opinion on climate change and human rights from the International Court of Justice. So it's really wonderful to speak after Sophie, and particularly to speak after Sophie, after she's just shared with us the incredible victory that was achieved in the Torres Strait Islanders communication to the Human Rights Committee. Of course, I think many of us were hoping for a favorable outcome, and it's not a perfect outcome as Sophie explained, but it is one that is incredibly important, and that gives a lot of hope, I think, for climate justice generally, but also specifically for the prospects of using international law and mechanisms to advance climate justice, especially for those who are disadvantaged or marginalized or vulnerable. So the notion that international law must be brought to bear on this big problem of climate change and the related injustices of the climate crisis is also at the heart of Vanuatu's initiative to seek an advisory opinion from the ICJ. Of course, there is a legal regime in place to address climate change. The UN Framework Convention on Climate Change, as you all know, was adopted in 1992 at the Rio conference, along with a number of other very important international treaties. It remains an incredibly important treaty, which may be called the Constitution of International Climate Change Law. Its ultimate objective of preventing dangerous anthropogenic interference with the climate system remains incredibly important. At the same time, I think if we all read this, the formulation of this objective in the convention, we must admit that we have failed to achieve that objective. Dangerous anthropogenic interference with the climate system has not been prevented, and so we see the adverse effects of climate change, manifestations of dangerous climate change already happening in the world today and affecting mostly marginalized groups and especially in developing countries, though not only, of course, but especially in developing countries. And so the increased awareness of the injustices of climate change, I think, have been an important driver for different initiatives seeking to link climate change and human rights. So many of you here in the audience will be familiar with the very first rights-based climate case that was brought by Inuit communities before the Inter-American Commission of Human Rights in the mid-2000s. At that time, the Inter-American Commission was not well equipped to address the petition that was submitted to them, and so it didn't even reach the admissibility stage. Instead, it was the commission sent a letter to the indigenous groups who had brought the claim, saying that they did not have sufficient information to establish whether violations of rights had occurred. And that was brought against the United States, of course. And not, even though that didn't lead to a formal court commission victory, it did inspire other rights-based initiatives to address climate change. And so the legal advisor of the Maldives, Mark Limon, was inspired to explore possibilities for small island developing states to use the human rights discourse and also human rights mechanisms to address climate change. So this led to the adoption of the Bali Declaration, and then in which the SIDS leaders committed to try and put climate change on the agenda of the Human Rights Council. Many of you know also the history of climate change at the Human Rights Council, the first resolution adopted in 2008. And today we have a long kind of chain of resolutions, the latest of which established finally, after more than a decade of advocacy by NGOs and several states, as the mandate of a special rapporteur on climate change and human rights. So all of this progress has been made, and of course, it would be a big omission on my part to mention all the now more than dozens of rights-based climate cases that have been brought before domestic courts, and then increasingly also before regional and international human rights bodies, including incredibly important case that Sophie just discussed, but also dozens of cases before domestic courts, such as the well-known Legari case in Pakistan, on behalf of a Pakistani farmer, where the Pakistani state was ordered to basically implement its own climate change law and establish a climate change commission that would oversee adaptation and mitigation activities, as well as the agenda case and many similar cases in which states were held to account for insufficiently ambitious climate targets. So all of this has been happening in a relatively short period of time. Most of these activities in rights-based climate litigation have occurred in the past decades. And so there's much to build upon. We also see that progress is incremental, right? There's not a one single case or initiative that is really saving the planet or that is delivering climate justice at once. It is very much a question of one initiative building on the next and on the next, etc. And there are also setbacks detectable, but generally, I do think that it's possible to say that the glass is half full. So this is a bit of context. Now, why this initiative to bring climate change before the International Court of Justice? So one, I think, reason why this initiative emerged from the Pacific, and Solomon will speak in much more detail and more knowledgeably about this. But one significant fact is that for states like Vanuatu or the Solomon Islands or Tuvalu, the small island developing states, the options of litigating climate change are limited. And so the Torres Strait Islanders, of course, could sue the Australian state, which made a lot of sense. Australia being a big polluter and also having significant resources to assist with adaptation action. And states, of course, the situation you soon exploring options before international courts and tribunals. And so back in 2015, a very comprehensive mapping exercise was carried out on behalf of the government of Vanuatu to explore what are the various options for Vanuatu to spur. And basically this initiative was identified as the one that holds most or as the Pacific Island students fighting climate change like to say, bringing the biggest problem of our time before the world's highest court. And so steps in this direction were taken soon after. It was in 2019 that Vanuatu convened the first formal meeting to discuss the initiative in a diplomatic community in New York, the margins of the Climate Action Summit that was convened by the UN Secretary General. And since then, tremendous capacity building work has happened, because what is really important about this initiative is that it's grassroots driven and that it's also supported by not only civil society, but in Vanuatu across the Pacific, but also by all branches of government. And the civil service and the full diplomatic staff of Vanuatu. Vanuatu has even hired several new diplomatic experts, advisors, and others to assist with the initiative in Brussels, in New York, in Geneva, and in Port Vila. So where does the initiative stand now? In a nutshell, Vanuatu is gearing up to officially put the initiative on the agenda of the UNGA next week, 27th of October. That's when the UN General Assembly will discuss the report of the International Court of Justice, as it does every year. And that provides a good opportunity for Vanuatu to place the initiative on the agenda. So that is really around the corner. And as you can imagine, a tremendous diplomatic campaign is in full swing to make sure that when the resolution is formally tabled at the UNGA, there will be an overwhelming majority of UN member states voting in favor if it comes to a vote. And so far, the various SIDS constituencies have formally expressed support. That includes CARICOM, as well as the Pacific Island Forum, notably including Australia and New Zealand. Australia, not surprisingly, under the new government. And also the Organization of African, Caribbean and Pacific States, which has 79 members. So in terms of numbers, it's looking very good. And in terms of enthusiasm, it's perhaps looking even better. Not only are governments from all regions generally enthusiastic of the initiative and have reached out to Vanuatu to express support, but also is there a fantastic and very inspiring civil society campaign led by Pacific Youth that is really ensuring that the initiative has enormous visibility globally and in different countries, and that governments are asked by their own citizens and youth to show climate ambition and to also show solidarity with the SIDS that are driving this initiative. So I will leave it at this, and then hand over to Solomon, who will be
Thank you so much, Margaretha, and for those really interesting insights. And as you've kind of touched upon already, I think it's been really inspiring to see the big campaign surrounding this. And so this is why I'm also really happy to have Solomon here with us today, who will talk about the youth movement that has led us to this moment. So Solomon, I would invite you to join me, and the floor is yours.
All right. Thank you very much, Leah. I would try to share my screen as much as I can at the moment. Everyone can see this? Anyone confirm? Oh.
Yes, we can see.
Okay. Thank you. Well, first and foremost, thank you for the organizers for having me here today. And this is a very exciting panel. I also heard a lot of great things about the progress of the Torres Strait Islanders case. And this is, of course, one of the cases that we have been following from the past, given it's coming from next door neighbors and, of course, part of the Pacific Islanders as well. It's really inspiring to see how far it has come, and I would only wish it to go along the way. And it is very inspiring as well for many of us to see this happening in the court. And of course, also doing the same thing as well in trying to also getting help to utilizing the legal system to really bring about change on climate change. Also very grateful that I'm together in this panel with my former teacher, Professor Margaretha Wewerinke. I think it was last time I remember seeing her for the first time in University of South Pacific back in Vanuatu. And I never thought that we would be doing a campaign together or working alongside my teacher as well. And this level and intensity of a campaign, it's really great to be here together with her and also in the same city as her as well. So that's never thought that it would come to this. Margaretha also highlighted tremendous efforts. I think that's still very understatement yet, because amount of work that civil society, youth and government from the Pacific are working on this is incredible, and also very scary as well, how much human beings can work on a particular campaign. So I'm really reassured that at least people are working extremely hard on this campaign. And I heard today that there will be students, most of the audience will be students, so I will try to make sure that I share about our stories as when we started the campaign back in 2019. So my presentation today, understanding we're short on time, is just divided into 3 parts. First, I'll talk to you about the origin story, where this campaign came about, and I'll talk about a little bit of how the movement came into be, and then looking ahead of what are we anticipating for in the future on the campaign. So take you back to 2019 to this university in the Pacific called the University of South Pacific. And it was a regional university, so parts of the university, the law school is based in Vanuatu and called the MLS campus. So back then there were, as we were finally law students, we decided, look, we need to really do something about the climate crisis, of course, not just band-aid solutions. We really need to go higher and more ambitious on this. So we formed together a group, and then we did some research, and then we came up with the advisory opinion campaign, which we believe that it's the right step that Pacific governments should take forward to the international community and get the international community behind it to take the matter to the International Court of Justice. So we decided to advance that campaign. But alongside that, we also decided that it's really great to also understand the campaign. We understand the concern about climate change, and also really great to educate and activate other young people in the Pacific. So that's primarily the 2 main objectives of the Pacific Island students fighting climate change. But just taking you also deeper on what I was really motivated by personally on this campaign is the fact that it was in that class, I recall, for the first time, of course, climate change in the Pacific, we're, I would say, living experts to it. We see it daily, and the impacts are, of course, intensifying by the day, but never ever heard for the first time the nexus between how climate change is impacting us through our human rights. And of course, it's just an obvious thing, but never ever see that in that frame, or even thought that was possible in the first place under domestic or international law. And of course, it's right to assume as there's a lot of struggle to get this to be recognized. But looking back in the Pacific, you can see so many climate impacts really undermining the ability of Pacific Islanders to exercise and enjoy their basic human rights, so right to water, right to housing, a lot of other these basic rights that we need to survive as a human being, or is essential to us. And then looking back in the sitting in that, in my desk that time, thinking about Cyclone Pam in 2015, a major category 5 cyclone that swept through Vanuatu and to other Pacific Island countries and left devastation. So just over in one night, the country lost about 64.1% of its GDP, which of course in any country around the world, that would mean state collapse instantaneously in terms of economic wise. And of course, the impacts to its human lives is tremendous. So there is a nexus in my understanding between climate change and human rights. And another thing is that there's this interesting, through our research, we come across this interesting case by Gapchikoa and Nagimoro's case. It's a river issue between 2 countries in Europe. And in this case, it was interesting that one of the Judge Wewerinke went in great detail to explain the concept of intergenerational equity principle, which he, from his, of course, brilliant explanations, he drew from an example in the Pacific, where when back in the colonial days, a Pacific Solomon Islander from my country was called upon by the administrators and asking whether that he should sell his land or sell his community land. And he was really disappointed about that concept of treating land as a commodity and as it was a thing like a box that you can sell. So Judge Wewerinke highlighted that, and from that I would believe formed the basis of his judgment. One of his judgment, and quoting his judgment, is saying that land is never subject of human ownership, but is only held in trust, with all the connotation that follow of due, wise management and custody for the future generation. And that made me reflect a lot about how we Pacific Islanders have lived throughout history, and of course many communities and societies out there in the world that always practice in understanding that we should not infringe we should not hand over a society to the next succeeding generation, that one that will undermine them. Rather, it should be added value to them. And as we can see in the world today, this is not the future that our children should be living in. And of course, looking at the science, we know that it's not going to get any way better. And of course, we are not stopping it yet, given the lack of progress in international regime. As the Margaretha has highlighted, the Paris Agreement, it's great and all, but the pace that it's going at, it's incredibly concerning, as we do not have much year before the point of no return, where damages and climate action cannot be meaningful because it's beyond the point of no return. So from that understanding, human rights and intergenerational equity, we also come about the initiative of one of the Pacific governments, the Palau government back in 2011, where they did attempted to take forward the case of seeking an advisory opinion through the International Court of Justice on climate change. But unfortunately, they did not manage to go through. And we have thought about it, and like, this is probably the right timing now. We have the case from Juliana back in 2015. We have the Uganda case. We also have other cases alongside that really solidify that there's a nexus between human rights and climate change. So we decided, why not build a campaign around this and initiate it towards. But if I could just go in a bit more into storytelling narrative, the campaign is really much associated with the vaka. So the vaka is a traditional vessel that is aimed to transport people, just relying on stars and birds, how bird patterns, observations, oral history from past generations, and the ocean and the wind. So these are traditional vessels from the Pacific Island used to traverse vast distances of oceans to get to places in the past. And it still is a very integral part of Pacific culture. It forms an intimate connection between the people, communities, land, and islands and the sea. So it's also very, we built the campaign around this vaka because it's very synonymous to a journey or a voyage, as you may call it. So the vaka at the moment the campaign really started from the Pacific, is carrying forward the calls for greater justice, and is calling for the protection of the rights of the current and future generation from the adverse effects of climate change, and carrying it forward to the international community and to the International Court of Justice. So the campaign is much revolved around that, and it will continue to be so, and truly reflective of that as well. Oh, yeah. So in encapsulating that, one thing that if you must know about the International Court of Justice advisory opinion, one thing that is the heart of it is the legal question. What is the legal question that you wanting to ask to the court? And I recall there's a past session, I don't know if it's the following year or the year before that, by ClientEarth, the same one that we're having right now. One of the professors there really highlighted that the concern about the legal question that you put forward, and of course, rightly do so, because you want to ask a question that's really important and right in the right context. You don't want to ask a very weak question to the court. But on our end, what we really want to look forward to is really from the understanding from our research is really what are the obligations of states under international to protect the rights of the current and future generation from the adverse effects of climate change. And from that arguments, you can pick out two themes that we focused on, which is human rights and intergenerational equity. We want the court to draw upon its shed upon its light on this, but these are really necessary in terms of addressing climate change, state obligations for the governments, or whether there's obligation to protect these rights as well. So that's the essence of the Youth and Civil Society campaign. A caveat that this is not the campaign that the government is pushing for, although they acknowledge this campaign much well, which I will cover later on. So going into part 2, movement building. It started when we started at the first beginning. Then when doing a research, we have come across that the fact that the advisory opinion, as you can see from the Palau initiative, it's not a campaign that we just came up with it out of the blue. It's something that has been attempted so many times by so many people because they acknowledge how important it is in terms of addressing climate change. But one of the professors that we wrote out and reached out to really captured the attention on this, where he said, I support this initiative, and he did try to advocate for it. but realizing that it can be only successful if there's a strong grassroots movement behind it. And that's essentially what I will be talking about, how the fact that how relevant and important, why that those one sentence really matter in this campaign. So that really inspired us as students, really. And we started off the campaign. So we decided to write to our leaders. As you can see on the screen here, these are the first actual letter that was sent to the government, our governments, 18 member states, to the Pacific Island Forum, and also the signatures of the 27 law students who started this campaign. And writing back to them, we also thought that, look, writing the thing and communicating to our leaders is not enough. We really need to get the support, as you've seen the email, need the support of the grassroots. So really reaching out to our people in our communities, reaching out to our civil society, and galvanizing a lot of support behind that. Because I think the really strength of this campaign is about the fact that these communities and civil society see that these people who carrying forward this campaign actually from the Pacific. It's not a foreign idea that's been introduced, of course, influenced, but not introduced and, you know, spearheaded by outside forces, but actually their own people taking this campaign onwards. So you can see the excitement, enthusiasm of people supporting this as well. We also managed to convince our university. All of our staffs are very proud of the fact that we're doing this. Margaretha is still a professor to the USP, but as well as a lot of them have grown quite inspiration and really put in their way to really support it as whatever they can and really help push the movement to this state the way it is. So through all that collective activism with our communities, our university, our lecturers, and our people, we managed to push forward and get the endorsement from our leaders at the Pacific Island Forum just earlier this year in July. It took a bit of a while because of the COVID, but we somehow managed to scrape by and get it through the Pacific Island Forum to endorse it. So the leaders acknowledged the campaign and decided to initiate the process of requesting it. And this is, as you can see, it highlights those key elements, which is human rights and intergenerational equity. So then we decided that it's, you know, from the Pacific, it's not enough, because if you want to get it through the United Nations General Assembly, you need a simple majority vote. So therefore, in our back of our mind, we already carry the fact that we need to build a global movement in order for this to succeed. We need every government, every civil society, youth around the world to be empowered and encourage the government to support this initiative and take it to the International Court of Justice. So in doing so, two things came out of that as a step forward. One is the formation of the World Youth for Climate Justice, and another is the Alliance for Climate Justice Advisory Opinion. So I'll take you to what those means. So just coming back to WYCJ, WYCJ is a network that we formed together with this, as you can see, some of this youth here, but not all of them. We call ourselves the stubborn optimist. Of course, you have to keep positive while you're doing this climate change, depressing climate change work. So all these students together, friends, we got it together and formed this network that collectively unite all of the young people around the world who are really convinced by the campaign and decided to join hand in hand to encourage governments across the world. And therefore, the other one is being the Alliance of a Civil Society Advisory Opinion. So this also another grouping that we united all of the civil society, the big civil society who are very interested in this campaign to climb on board and collectively campaign this to, you know, accelerate the process of getting more states on board. So as you can see, some logos are recognizable. Just to highlight a few, you have Greenpeace, Amnesty International, CAN International, and so forth. So almost 1,500 civil society have banded together to support this campaign. So precisely what this campaign look on a day-to-day basis? So basically what we try to do is that you can understand how technical the campaign is and really abstract, you might say. But what we did really is that why not transform that into a more like something that's simplified that ordinary people can understand. So we did a lot of that simplification. Of course, it wasn't easy because it was really hard translating that legal language into an ordinary person's language. We did through animation. We prepared a toolkit to simplify it, to help people understand through art, through media releases, opinion pieces, those kind of things. We also secured a large partnership and endorsement from other civil society and religious groups, academia, and other stakeholders who really added on to the spark and really make this campaign go bigger, and really to work with our respective governments to support as well the diplomatic campaign, of course. just to give a taste that some people might think, oh, government, civil society working together, that's odd. But for us in the Pacific, that's nothing new. It's given that geographically we're very small, your uncle can be your prime minister, or your auntie could be someone you just meet along, you go to the same restaurant every day or something like that. So we work hand in hand in a lot of projects, and of course for the benefit of our people. And on this campaign, it's quite easy to really work together on this, but I'm sure other countries are not. But nevertheless, it is important that we have continuously working with the governments who are really supporting and bringing this campaign on a global level, on a state level as well. And of course, remaining center in our campaigns are the two themes, human rights and intergenerational equity, which I covered already. And campaigners around the world, present now in all regions around the world, and hopefully more people will join on to really encourage the government to support this initiative. And ICJO being a key regional ask of civil society and non-state actors towards on climate change. So almost at the end. So part 3, looking ahead. So what now and heading onwards? So right now, as Margaretha highlighted, we will be having great events at the UN, at the New York, where we will talk much about the resolution. But then on the 27th of October, we anticipate the government of Vanuatu, the lead state, to introduce it to the United Nations General Assembly, which would then become public, I would guess, to the rest of the world to see what is precisely included in that resolution. Then that kickstarts the step of informals and formals, where governments around the world will have to come and negotiate negotiate on the zero draft of that resolution, what things that they don't agree on, what things they do not agree on, before they go to the voting at the end, which would require a simple majority vote of states. But onwards would be COP27, which is a very important event, of course, for climate change. But for this campaign, it's very important because the fact that this presents the final opportunity before we go into the voting stage of the ICJO campaign. So this presents the key moment where civil society and youth and governments can work together to amplify and get more states they can to support this when the vote comes in the final step here in December, anytime between December or February. Yeah, so that brings the end to that. But one thing you could potentially do to support this campaign is really to sign the petition that is available on our website, and really did what we actually did in the beginning, to write to our leaders. I think it would be more beneficial to really write to your leaders with attaching the zero draft resolution that will come out at the end of the month, and asking them to support this initiative. So to conclude, we can see that human rights and climate change and human rights crisis, the climate crisis is a human rights crisis, at least for Pacific Islanders. I see this on reality on the ground. I also endure it, I also feel it as well. And you can see past efforts like the Palau initiative, and I'm sure thousands or hundreds of other initiatives in the past that brought forward case to litigation and failed. That is, to us, it does not seem as a failure, but it's we acknowledge them for their bravery, because of those people who attempted to do the unthinkable really paved the way for people and other cases around the world to go forward in courts. So if those people didn't attempt it, we would not be here in the first place. So I concur with some of our previous speakers who highlighted this. And just a reminder that the Pacific Islands countries at the moment, they're not doing this for themselves, but they're doing this for the rest of all of human beings around the world, and of course for the future generation. So why not support this cause, as we understand that this is an incredible big issue that no country alone should be able to bear on this. And at least we should understand that when we are facing that end of the line, looking down the barrel of the gun, and we have tried all initiatives, we haven't yet explored all solutions that is available to us. That is a problem for us. We, at this stage in time and point of history in humankind, this is where we must utilize all available tools from us, and in our case, to take the world's biggest problem to the world's highest court. And finally, I would like to just end here, and I don't want to mess this up, so I'll have to read it to you. All I can say is that the Climate Justice VACA is now sailing to take the world's biggest problem to the world's highest court. And carrying on board is forward the voices of the unheard and the people who have been forgotten, and of course the succeeding generation. but there is a toll to pay along the way. It requires a simple majority vote from the United Nations General Assembly. So my question I would leave forward to the people here who attended today is that will your government climb aboard the climate justice FACA and vote yes for climate justice when the time comes in December or February at those times? Thank you, and thank you, Tomas.
Thank you so much, Solomon, for sharing, first of all, your very impressive work and the very impressive campaign with us, but also your personal experience. I would like the three panelists to now join me and open the floor for discussion and questions. So please make sure to put your questions into the Q&A box. I think one of the things that struck me during your presentations, Sophie kind of touched on the fact that there's no right to collective, or there's no collective rights in some of these international human rights instruments. And Solomon touched upon the view of land as a commodity. And so I would be interested in hearing some of the challenges that you see with the existing international human rights framework and legal framework in encompassing, or maybe also reflecting some of those realities that are different from those of the drafters of some of these documents, and how you feel that some of these instruments can nonetheless be used to align with these different ways of interacting with the environment and with one another that sometimes weren't accounted for in some of these documents. And Solomon, if you could join us as well, that would be great.
I suppose I'll attempt a response. I think you've asked about the challenges of fitting climate into existing treaties and the developing interpretation of those treaties through time. I think that is a challenge, but potentially less of a challenge for decision makers and committee members or judges in the EC, in the European system, for example, or the Inter-American system, who I think are quite used to seeing the treaties as living instruments, and generally do tend to, within obviously reasonable limits, develop those treaties through time. So, for example, obviously there are implied rights to a healthy environment in the European Convention, and there's plenty of case law that implies that the right to family and home in Article 8 of the European Convention protects people from impacts that affect their health at home, and impacts of environmental degradation that affects their health and their home life. So I suppose that sort of right to a healthy environment has been implied already. So not so worried about that kind of interpretive development of the law, but I'm more concerned about just basic procedural issues, such as states not signing up to the optional protocols that give the treaty bodies jurisdiction in many of these matters. I mean, and even signing up to the treaties themselves. You know, the US is not a party to any of the to any of the optional protocols, as I understand, and sees itself as even sitting outside of international law of the sea. So international law is fundamentally based on state consent, and that is, I'd say, one of its main weaknesses when attempting to enforce against more powerful states.
Thank you. Margaretha, I don't know if you have anything to add on to that. One of the questions that we also got in the chat was, in light of strategic climate litigation, especially regarding other continents such as Latin America, do you consider bringing these cases to international tribunals or institutions more effective than litigating on a national level? And what are the advantages and disadvantages from your points of view?
Yeah, it's a great topic of discussion, of course. The advantages and disadvantages of national versus international level litigation, and on the
Sorry, Margaretha, I think you're a little bit frozen.
states, it really wouldn't make. And so the situation there different.
Margaretha, can you hear me? I think your connection is a little bit frozen.
That in the case of Australia and international level climate litigation have been pursued, and I think that probably in this case also question of
Margaretha, maybe if you turned off your camera, that might be helpful. We're having a hard time hearing you.
Sure. So yeah, I guess what I was saying is that national versus international may not necessarily be either or a question. We don't have much time to lose. And we see also, when we look at, for example, what the Human Rights Committee said about the admissibility of the Torres Strait Islanders claim, that human rights bodies also realize that they have a complementary role to play that requires them to look at, for example, the exhaustion of domestic remedies requirements in a way that is not overly rigid. And so the approach, for example, that the Committee on the Rights of the Child took in the Saki versus Argentina complaint has been criticized quite a bit, I think, in legal commentary and in literature as being too rigid, where the committee said that basically in almost all circumstances, domestic litigation must be pursued first. So it's a nuanced picture, I would say.
Yeah, and I wonder to what extent also, some of the outcomes of the possible advisory opinion, then will also once again interplay with the national level and can potentially also be taken forward on the national level. So I think, as you said, I liked the phrase complementary roles. I think that's really, really important. And as we're all aware, time is running out. So thank you for that input. Sophie, there is a question directed at you that's asking that the question is, the Human Rights Council took a more harmonized approach in its views in the Torres Strait case. Margaretha pointed out the difference between the rights-based approach and that of the international climate regime. So do you think that intertwining, or rather harmonizing these regimes will matter, or will be a way to go in future cases for them to be successful?
I think that yes, but I think now that is not too controversial, that harmonized view, because I think that the committee accepted that in its general comment. I think that Australia's position was pretty untenable, and they were really actually asking the committee to go against its own comment. So it's a less popular view, I believe, but I'd be interested to hear what Margaretha thinks about that, about how the Paris Agreement interacts with international human rights law.
It's again a very complex question if you look at it carefully. But I think at its core, it's about the Paris Agreement providing an indication to human rights bodies about a level of protection that states have already agreed that they will provide, and that is mainly the long-term temperature goals. And then we no longer have obviously quantified emission reduction targets. as we did in the Kyoto Protocol. So science is needed to interpret what that means in specific context. So that is really important, as well as, of course, the notion that loss and damage is already being suffered, as it's recognized in Article 8 of the treaty, and then the implications that flow from that. And ultimately, what it boils down to is really an exercise of creative interpretation, isn't it? Seeing what are the different standards. There's no clear answer there, but then again, there are very important principles that help, that should drive and inspire the exercise of interpretation, such as the principle that rights protected under human rights law must be practical and effective, must be interpreted in a way to make the safeguards practical and effective. And so that then, presses in favor of certain interpretations and excludes others that would lead to, the absence of sufficient protection.
And so, Solomon, to tie you a little bit back in as well. So how do you feel in terms of, having heard some of these things, how these kind of interact with your campaigns, and where do you maybe also hope to see your work going following the hopefully successful conclusion of an advisory opinion? Where do you see this work going, and what do you feel, and what role do you feel that the Pacific Island students also have to play in the future?
Thank you, Leah. I don't know, in terms of the last part of your question, in terms of where the role of PISLWC would play. By that time, I might not be a youth anymore. But I guess it's not about the vehicle itself, but also the people behind the vehicle. We are, of course, Pacific Islanders. We live on this very treasured region in the world, looking after the Pacific Ocean, as well as living as in our own sovereign right as individuals and human and community of peoples. So, but given climate crisis is a long-term issue, an advisory opinion is not really something that we see as an end game. It's just it's not a magical wand that when we achieve it, it will wipe away the climate crisis. But nevertheless, it is a step towards that process of accelerating and catalyzing more ambitious actions that we desperately need, not just from the law, but science, from technology, from community, from social, all aspects of human society that really needs to improve. And that one thing, that advisory opinion that we hope that we want to see is really that it can really catalyze and inspire more actions coming out of these facets of society. And in order to do that, is that something that I've all been conflicted by doing this campaign, is that looking in the past and all advisory opinions, I think advisory opinions can only be truly meaningful if ordinary people actually use it to their advantage. So this campaign is really basically to give a tool to people around the world who's concerned about the environment, concerned about the climate system, concerned about their basic human rights being undermined by climate crisis, and decide that they want to do more action about it. This is a tool that they could potentially use to bring about favorable outcomes in shaping the way the economy evolves, shaping the way the society evolves, and going into the future, and how we're going to create a future that we can, as I've said in my presentation, hand over to a future generation. Is it going to be a downgrade, or is it going to be an upgrade? That's the question we'll ask for ourselves, and let it be the future generation who be the judge of that. But as I've said, this is a campaign that we're hoping to see more actions that are coming out of it. And we believe that when we achieve this, it's really great in the process as well, to hopefully ordinary people, citizens impacted by climate change, can also be part of their delegations when making forward the stories and submissions, whether it's a written submission or submission before the court, and hoping that will also adding their voice directly into the process as well. And yeah, we look forward to that, of course.
Thank you. And I think, because we only have a couple of minutes left, but I had a last point I kind of wanted to pick up on, because Sophie, one of the things that you shared with us and about the remedies that were found and the issue of compensation. And I think compensation is something that has come up, you know, in the context of loss and damage. I know, Margaretha, that you have thought and written about this as well. And obviously this is something also to think about within the context of a possible advisory opinion and the topic of intergeneral equity and justice as well. And so I would be interested to hear, first of all, how you envision that some of these conversations will go, and also what you and the claimants are potentially hoping and going to be asking for. And Margaretha, how you maybe see that some of the work that you're doing is not a continuation, but builds onto maybe some of these findings as well.
I think that loss and damage is front and center at COP this year, which is really great to see. But I think post-pandemic, my cynicism level has significantly increased, and I actually don't believe that there will be a transfer of loss and damage finance or funding unless courts order it. The courts in the global north. So I think personally that's where we should be putting our effort. The GFC is, you know, chronically underfunded. There's not the adaptation funding that is going to the developing world to pay for adaptation, and these costs will just mount and mount and mount. So we're in this compounding problem. I think the courts are one of the best ways to encourage payments and transfers of wealth and to enhance redistributive justice in the face of climate injustice. But of course, if that can be achieved through the negotiations and the diplomatic process with additional pressure of things like the advisory opinion, then that would be absolutely brilliant and a better outcome. But personally, I think we'll probably have to see courts award damages before we'll see the scale and scope of the transfers that we need to see.
Thank you.
Yeah, I completely agree with everything that Sophie has just said. And to add to that, I think maybe worth noting also the symbolic importance of initiatives such as Vanuatu and the whole campaign about really, and the same goes for, of course, the initiative of Antigua and Barbuda and Tuvalu and Palau, to establish a commission on small island states on climate change and international law. And these initiatives are really also about showing that the international rule of law can be brought to bear on climate change, including questions relating to loss and damage. And so addressing this question is not a matter that is about charity or just voluntary actions on the part of developed states, but it is also about legal obligations. And so the Human Rights Committee's views are not at all revolutionary or groundbreaking in the sense that they apply very well established principles of general international law and of international human rights law. But they're just, in a way, a very logical, traditional, you can say, application of those rules. But of course, seeing that happening does have tremendous symbolic and also legal consequences.
Thank you so much. As we're 3 minutes away from being on time, I just want to ask if any of the panelists would like to share any final comments or thoughts. Otherwise, I would like to thank all of you for being here, for participating. We will show a quick survey at the end that we just use internally to understand who joins our webinars, if you found them informative and interesting. And if you also have any ideas for topics that you would like to talk about in the future, please do put them in the chat. And then that just leaves me to thank my panelists as well for being here. I learned a lot today. I think I've been very inspired by all of the work that you all do with your kind of different initiatives and cases. And especially to Margaretha and Solomon, best of luck with your efforts going forwards, and hopefully see you all again very soon. Oh, Margaretha, sorry, you just put your hand up or wave goodbye.
It was meant to be a waving hand indeed.
Thank you all so much. Bye-bye.
Bye.